Sí. Recording in progress.
Good afternoon, members and colleagues.
Hi, Eddie.
Hi, hi.
Hi, Eddie.
Hi, how are you? How are you?
Good afternoon, Chairperson.
Yeah.
Good afternoon.
Good afternoon. Good afternoon. I'm just waiting for Chairperson. Just WhatsApp him now for him to join the meeting. So if we can give him some few minutes.
Thanks, Eddie. Can you make me a co-host so long, please?
Greetings to Matonsi and members.
Good afternoon, Chair. We do have 8 members, and then we can start with the meeting, Chair.
Okay, thanks very much, members, and thanks for attending this meeting. I know that we're just coming from the mini plenaries which are underway, and thanks also for guiding us to have this special meeting to deal with these items that are on the agenda. We hope that observing that today is Friday, and since we've started many plenaries in the morning, we think that all of us will contribute so that we'll focus on the areas that we ought to deal with. We've rescheduled this meeting to today because on Tuesday we were to deal with the Border Management Authority and also the government printing works, where members were given time to deliberate on the issues that are arising from the report of the PMA and also the government printing works. We have also 4 questions that are before the Border Management Authority, that will request also the secretariat team to make follow-up on them, not follow-up, but also formally communicate to them, so that when they respond on Tuesday, at least are part of the issues that they were raising. So we'll deal with the issues that are before the committee. We'll then request a slightly change, take the item number 3 to, no, sorry. Can you highlight the agenda, Mr. Matonsi? I thought number 3 is an apology.
Can you see it, Chairperson? Yeah, okay.
Yeah, I can see it. Then we'll, because we're at the agenda on Tuesday, we're to deal with the BMA, and the second item was on the government printing works. The third item was immigration, responses, a legal team, and the last item was the political party funding. So we'll stand with that agenda. Then it will mean that item number 3 will be followed by the responses from the Home Affairs Department and legal team, then questions if are there, and then outline a process how we're going to deal with this matter of deliberations, and then we'll deal with the number party political funding, and then we engage on it. Then that will be the end of our sessions once members have guided. Can I invite you, Mr. Matonsi, to item number 2 and also introduce, give an indication who's in attendance. Obviously, members, honorable members are in attendance, and other stakeholders that are in the meeting. Thank you.
Yes, Chairperson, apologies. I've got an apology from Reverend Nishwe. There's an apology as well from Ms. Ngobeni. We know that no, she's off sick. And also there's an apology from the Minister of Home Affairs. And then also there's an apology from Telane, from Parliament Legal Service. But Ms. Charmaine van der Merwe is here in the meeting on her behalf. I think that's all from the stakeholders that are here. Is the department. I see that there's the deputy minister is in the meeting, the DG, Moses Malakate, Advocate Albert Matsau, and then Advocate Gam, and then also there's Rias and Mose. And then I saw UNHCR as well. They are here in the meeting, Chairperson. I think that's all from my side.
Okay, thanks very much. And also extend greetings to all stakeholders in attendance, department led here by Deputy Minister and the Head of Administration, Director General, and all your team. I will now invite you, Deputy Minister, to introduce and all apologies accepted and noted, to introduce the presentation. Thank you.
Thank you very much, Chair, and greetings to all committee members. With me here, I have the Director General for Home Affairs, Mr. Tommy Makote, and also Advocate Malapate. And I also have some of the staff from the political office of the Ministry and the Deputy Ministry. We have been requested by the committee today to present our responses subsequent to the submissions that were made about the amendment on the Immigration Act. I think you will remember that this was a result of a constitutional court judgment which had to deal with the constitutionality of the act resulting from the issues of right of detainees who were being arrested. And then subsequently, the committee ran the process and consultation. So we will be responding to each and every one of those consultations, of those inputs that we made. Some of them, Chair, will not have been major inputs. And again, I want to emphasize this point that our intention is just to respond on those substantive submissions that were made. I will then request that probably the Director General with Advocate Malapate then will take us through the presentation in more detail. Thank you, Chair.
Thank you, Deputy Minister. DG.
Hello, good morning, Chairperson, and good morning, DM, and also honorable members, the colleagues from Parliament, Legal Services, the DDG, Acting DDG, Immigration, and honorable members. I think the Deputy Minister, Chairperson, has given a very good summary. We're here to provide a response to written submissions from interested persons, institutions, NGOs that came and presented before your committee. In certain instances, we received written submissions, and for each, we'll then provide a response. You will note in the main, Chairperson, that we are dealing with a matter that the Constitutional Court has pronounced on. There are matters that were proposed, as you will note in the submissions that we received, that can better be dealt with in the white paper on citizenship, international migration, and refugee protection. And where those are supposed to be dealt with, we will also indicate because the Concord expects us to respond to specific matters that we need to do. So without any waste of time, Chairperson, I'll then invite Advocate Malakate just to take you through the presentation. Thank you, Chairperson.
Thank you very much, DG. Advocate. There was also, when Advocate still staying, there's also apology from Honorable Mohammed that will be joining us soon. Advocate Malagate.
Chairperson, if Advocate is battling, can I then proceed? If Eddie can load the presentation from that side for us.
Okay.
Or Mozi.
Thank you, DG.
Able to do that. I'm not sure why Advocate is not responding, but I spoke to him earlier and I see he's online. He might be battling with his device. Mozi, are you able to load the presentation from your side so that we proceed? Mr. Njoko?
Yes, teacher, I'm trying to upload it. Thank you.
Okay. Let's give it time 5 minutes and see if we can win.
Okay, let's have it on a slide mode, Mozi. Thank you. So Chairperson, I think as DM has indicated, we're here to present on the response to the submissions that were received from various entities, institutions, interested persons, and NGOs. If we can then move to the next slide, it's just the outline of the presentation will be the purpose which I've just indicated. And then, of course, the judgment on Section 34 of the Immigration Act 2002, and then the written submissions and our responses to each, and then the recommendations to the committee. By way of background, I think, Chairperson, we've already indicated that we're here to provide our response to written and oral submissions that were received by the Portfolio Committee relating to the Immigration Amendment Act. And then slide number 4, Chairperson, just recaps on the two judgments. The first one was Lawyers for Human Rights versus the Minister of Home Affairs in 2017. And then Lawyers for Human Rights versus the Minister of Home Affairs, which was a matter that dates back to 2023, and you'll all recall the judgment in the matter. So just to recap on the 2017 judgment on the next slide, you'll recall that on the 29th of June 2017, the Constitutional Court in the Lawyers for Human Rights versus the Minister of Home Affairs and others had indicated in particular that sections 34(1)(b) and D of the Principal Act is inconsistent with sections 12(1) and 35(2)(d) of the Constitution of the Republic of South Africa, and therefore that was then declared invalid. Further, the ConCourt held that Section 34(1) chairperson of the Principal Act does not require the detainee to be informed of the rights set out in Section 35(2) of the Constitution, which chairperson include the right to legal representation. The ConCourt further held that Section 34(1)(b) of the Principal Act does not require automatic judicial review of a detention before 30-day calendar days expire, and furthermore that Section 31(b) does not allow the detainee an opportunity to make representations to the court, either orally or in writing, or nor does it permit the detainee to appear in person before the court. If you move to the next slide, on slide number 6, the court also held that Section 34(1)(d) of the Act also does not permit the detainee to make representations to the court on whether the grounds advanced by an immigration officer meet the standard of good and reasonable grounds. And then further, the ConCourt held that Section 34(1)(d) of the Principal Act denies the detainee the right to challenge the lawfulness of his or her detention by appearing in person before a court, and the Constitutional Court held that to be contrary to Section 35(2) of D of the Constitution. The court further indicated that Section 34(1)(d) of the Principal Act is unconstitutional because it conferred a power to detain without any objectively determinable conditions or guidance for how to exercise that power. So you'll recall, Chairperson, that the declaration of invalidity was suspended for a period of 24 months from the date of the order to enable lawmakers, in this case Parliament, to correct the defects in sections 34(1)(b) and D of the Principal Act. And then, of course, if you go to the ex parte matter on the relating to the Minister of Home Affairs and others, the court ordered as follows. 1, it indicated that subject to and pending the enactment of legislation outlined in paragraph 2, as from the date of this order and pending remedial legislation to be enacted and brought into force within 12 months from the date of this order, the following provisions, supplementary to those contained in paragraph 4 of this court order of the 29th of June 2017, shall apply. A, it indicated that an immigration officer considering the arrest and detention of an illegal foreigner in terms of Section 34(1) of the Immigration Act must consider whether the interest of justice permit, and we had a long workshop, Chairperson, internally around this interest of justice, the release of such a person subject to reasonable conditions, and must not cause the person to be detained if the officer concludes that the interest of justice permit the release of such a person to reasonable conditions. B, it stated that a person detained in terms of Section 34(1) of the Act shall be brought before a court within 48 hours from the time of arrest or not later than the first court day after the expiry of the 48 hours, if 48 hours expired outside ordinary court days. Now, further, the court before whom a person is brought in terms of paragraph B must also consider the interest of justice, permit the release of such a person subject again, Chairperson, to reasonable conditions, and must, if it concludes, order the person to be released subject to those reasonable conditions. In D, it stated that if the court concludes that the interests of justice do not permit the release of such a person, the court may authorize further detention of the person for a period not exceeding 30 calendar days. And then in E, it stated that if the court has ordered the further detention of a person in terms of paragraph D above, the said person must again be brought before the court before the expiry of the period of detention authorized by the court, and the court must again consider whether the interest of justice permit the release of such a person, again, chairperson, subject to reasonable conditions, and must, if it is so concludes, order the person to be released subject to those reasonable conditions. And in F, if the court contemplated in paragraph E above concludes that the interests of justice do not permit the release of such a person, the court may authorize the person's detention for an adequate period not exceeding a further 90 calendar days. And then the last one was that a person brought before a court in terms of section B or paragraph B or E must be given an opportunity, Chair, to make representation to the court. And then in 2, it stated that if remedial legislation is not enacted and brought into force within the said 12-month period, the provisions in paragraph 1 shall continue to apply until such remedial legislation is enacted and brought into force. Here, the Concord chairperson was trying to make sure that we do not have the same lacuna that we had after the 2017 judgment. And then it then indicated that the interest of justice criterion comes from the ex parte matter related to the Minister of Home Affairs judgment, and the Concord ordered that when the release is considered, reasonable conditions may be set. And the last one was that the department must submit the bill in line with both judgments. So this is very crucial as we present this matter on the bill. Now, on page 10, Chair, we then start recapping on the provisions of the bill, just to refresh the minds of the members of Parliament as to what the provisions are. If you look at slide number 10, Muzi, clause 1 of the bill amends section 34 of the Immigration Act as follows. In A, there's a deletion in subsection 1 of paragraphs B and C, and then in B, there's a substitution in section 1 for paragraph C of the following paragraph, which is C shall be informed upon arrest or immediately thereafter of the rights set out in the preceding 2 paragraphs, paragraph A and subsection 1, capital A, G, when possible, practicable, and available in a language that he or she understands. And then in C, there's an insertion after subsection 1 of the following subsection. 1, capital A, an immigration officer, Chair, may arrest and detain an illegal foreigner for purposes of deportation, provided that in A, he or she has interviewed the foreigner concerned and considered whether the interests of justice permit the release of such a foreigner subject to reasonable conditions, and must, if he or she so concludes that the interests of justice permit the release of such a foreigner, impose reasonable conditions and record the release and reasons therefore on a prescribed form. And then on slide number 11, it's a continuation of the recap as to what is contained in the bill. On B, it says a foreigner so detained must be brought before a court in person within 48 hours, Chair, from the time of his or her arrest, or not later than the first court day after the expiry of the 48 hours, if the next 48 hours expired outside ordinary court days. And then in C, it says the court before whom the detained foreigner is brought must consider whether the interest of justice permit the release of such a person subject to reasonable conditions, and must, if it so concludes, order the person to be released subject to reasonable conditions. And then in D, Chair, it further states that if the court concludes that the interest of justice do not permit the release of such a person, the court may, apologies, there's a missing M, authorize the further detention of the foreigner concerned for a period not exceeding 30 days, And then in E, it says, if the court has ordered the further detention of such a foreigner, he or she must be brought before the court prior to the expiry of the period of detention authorized by the court, and the court must consider whether the interests of justice permit the release of such a foreigner, subject again to reasonable conditions, and must, it so concludes, order the foreigner to be released subject to reasonable conditions as imposed by the court. Now in F, Chairperson, which is the next slide on 12, it says, if the court considering further detention of such a foreigner concludes that the interest of justice do not permit the release of such a foreigner, the court may authorize the further detention of the foreigner for an adequate period not exceeding a further 90 calendar days. And then in G, lastly, it says a foreigner concerned brought before a court in terms of paragraph B or E must be given an opportunity to make representation to the court, and such representations must be considered together with representations by the immigration officer. So if you look on your right, clause 2 amends the Principal Act by the substitution for the word court wherever it occurs of the word court. And then clause 3 deals with the short title and commencement of the act. So we now move, Chairperson, to slide number 14, which then starts dealing with the written submissions that were then received. The first one was from the African National Congress. The summary of the written submission is that the ANC supports the Immigration Amendment Bill and its objectives, and the department response is that we note and of course appreciate that support. The second one was from the Congress of South African Trade Unions, COSATU, which also supported the Immigration Amendment Bill. And then there was also a call that references in the bill should be clarified to confirm that the courts in reference are magistrate courts. And then we, as a department, note and appreciate the support. And then our response is that Section 1 of the Immigration Act defines the courts. That's the point I was making earlier on slide 10, to mean magistrates court. So there's a detailed annexure that we have also submitted, annexure A, that comprehensive response department to all the issues that raised. Next one, the seal in principle, but they also indicated in their submission, Chairperson, that the bill should include provision illegal through aids as non-national or undocumented person. The CGE is further of the view that the bill should include provisions that align with existing gender frameworks and commitments. They further indicated that a greater focus should be placed on the potential social and economic benefits of the marginalized. Our response, similarly, Chairperson, we note and appreciate the support from the CGE, and in B, we indicate that Section 1 of the Immigration Act already contains the definition of illegal foreigner. Secondly, the definition, in our own view, Chair, is universally accepted. Thirdly, other legislations in the Republic uses the term, and any amendment will lead to further amendments of legislations not falling within the competence of the department. These are issues that we are of the view that for sure they can be further dealt with in the white paper. You will recall, Chairperson, that the Cabinet has requested us to work on a supplementary white paper on citizenship, international immigration, and refugee protection. So that's where some of those issues will be dealt with. Then the next one is from the Center for Child Law, particularly from the University of Pretoria, and they propose the inclusion of these key terms that will avoid confusion when officials are dealing with children whom they believe to fall under Section 34(1) of the Principal Act. And then in B, they indicate that it's important that the bill considers the roles and responsibilities of each of the role player, particularly police officials who exercise their power under provisions of the Section 34 of the Immigration Act when they come into contact with these children, and the fact that they indicate that due consideration must be given to, as studies show, that often unaccompanied migrants who are seeking asylum fear the risk of being arrested, detained, or deported. Our response, Chairperson, is that the standard operating procedures that we have developed in the department adequately deal and guide immigration officials in terms of how to look after children or where they are in contact with the children. And we also further wish to indicate that children are not detained. As you know, Chair, they are placed under places of safety through the Department of Social Development. If I move to slide number 16, further, it's a submission made by the Center for Child Law at the University of Pretoria. They also recommended, Chair, the insertion of section 34 capital B-A and 34(1) capital B, which will outline in detail the process to be followed for children who are alleged to be in the Republic irregularly. In Roman figure 1, section 34 capital 1 capital B-A, the indication is that where the alleged illegal foreigner is a child, they must not be detained, but must be dealt with as a child in need of care and protection in terms of section 151J of the Children's Act 38 of 2005. Further, they submitted that section 34(1) capital B and small letter b, where the alleged illegal foreigner alleges that they are a child and no reasonable alternative confirmation of the person's age is available, then the person must be referred for an age assessment in terms of section 48(2) of the Children's Act 38 of 2005. Our response is as follows, Chairperson, that the suggested amendments and insertions increases the scope of the bill and are not in line with the judgment by the Constitutional Court. We are of the view, Chairperson, that any further amendment should be considered during and form part of the supplementary work, as I indicated, which is currently underway on the white paper on citizenship, immigration, and refugee protection. As you recall, the title towards a complete overhaul of the immigration system in South Africa, which was approved by the sixth administration. Now, further, we also received from the Center for Social Justice at the University of Stellenbosch quite detailed comments. The first one was that taking this into account, the purpose of the bill can be said to mirror these values. They then recommend that there's a need to endorse the purpose of the bill as it is congruent with the values that underpin substantive equality, which undergirds South Africa's constitutional democracy. They were of the view that they endorsed the proposed amendment subject to further clarification as noted in 4.3.2 above, and that Parliament and the Department of Home Affairs are accordingly implored to undertake the SIM exercise, which is the Social Justice Impact Assessment Matrix, and investigate how the proposed amendment can be aligned so as not to treat everyone on a one-size-fits-all basis. So the proposed amendments, they further indicate that might benefit immensely from the investigation as recommended in 4.3.3.3 above, and they were of the view that the proposed amendments will reduce historical disadvantages with a view, Chairperson, to advancing equality for foreigners in South Africa, including equal enjoyment of Section 34 of the Act between foreigners and citizens. In G, they propose that amendments seem not to disappropriately advances or disadvantages a group, and therefore at this point and until, Chairperson, the investigation, there seem to be no need for less harmful alternatives. And then in H, they indicate that Parliament and Home Affairs to adopt a proactive approach through anticipatory social justice analysis, as we indicated at the top. Our response is as follows, Chairperson. The comments from the Center for Social Justice supporting the bill, I think, are noted, and we truly appreciate. With regards to other written submissions, we are of the view that the proposals will fit well in the white paper or in the supplementary policy, and of course, we'll consider subjecting the same to the social justice impact assessment matrix as recommended by the Center for Social Justice from the University of Stellenbosch. And then on the next page, Chairperson, it's the Lawyers for Human Rights. The Lawyers for Human Rights, or LHR in brief, they note that the use of the term of illegal foreigner throughout the bill purposes of this submission, unless a person or persons fall within the definition of asylum seeker or refugee outlined above. The term they indicate in their submission, migrant or migrants, will be used generally to refer to persons who are not citizens or nationals of South Africa, and they're of the view that the term illegal foreigner, as defined in the Immigration Act of 2002, will only be used to accurately code the term in the Immigration Act. In B, Chairperson, they propose the insertion of the definition of interest of justice, which I think it's something that should be taken into consideration. However, we are of a view that we should not support this. And then there's proposal on insertion of section 34(1) capital A(H), where they are proposing that the insertion of section 34(1) capital A, Roman figure 1, as follows. A court, in terms of sections B and E, must, in reaching any decision, consider whether there are alternatives to detention and available in each instance. And then they also propose insertion of section 34(1) capital B. Our response, Chairperson, are as follows. One is that Section 1 of the Immigration Act contains a definition of an illegal foreigner. The suggestion moves away from the provisions of the Act. And of course, this we are indicating, Chairperson, may properly be dealt with in the supplementary policy work that is underway. Further, the definition has been adopted in other domestic legislations, which, as we said, it might create a lacuna if other legislations are not amended. And this bill does not seek, as we indicate, Chair, to be a general laws amendment bill, which means it will be too wide and not deal specifically with issues that the Constitutional Court has given a deadline that we need to address. And in B, we then indicate that the proposed insertion of the definition of in the interest of justice, as I indicated, is not supported. We're of the view that the SOPs are best suited to provide guidance to immigration officers. C, we then indicate that the proposed insertions of the suggested sections then broadens the scope of the bill, and we are of the view that the scope be narrowed to deal only, as I indicated, with what the Concord has ordered us to do within a particular timeline. On the next page, which is slide number 19, Chair, it's a submission that we received from the National African Federated Chamber of Commerce and Industry, in short, and NAFCOC. In A, they indicate that the Immigration Amendment Bill needs to be clear and give first preference to local traders, particularly, Chairperson, in the informal sectors, because the current immigration landscape is marked by inefficiencies and confusion. In B, NAFCOC indicates that the Marriage Act must be amended to make it impossible or not easy for foreigners to use marriage as a bypass to acquire citizenship. I suppose, Chairperson, you have been traveling in the other provinces seeking or soliciting comments on the marriages bill. For sure, that's where this can be dealt with. And then in C, they then indicate that like in all other countries in the Northern and Southern Hemisphere, Measures must be used to control their entry and their stay, as well as their access to medical, schools, and departures. As you note, some of the proposals might not be consistent with constitutional provisions. And then in E, they indicate that foreigners must have a different passport from indigenous or indigenous citizens. And then in F, they propose that foreigners should have a conditional acquisition of property and or land. In G, they indicate that dual or multiple residential permits should be reviewed or done away with or amendment. I think that's part of what we are currently dealing with in the supplementary work, where we're saying our visa categories are too many. We've got about 17. We are now saying we need to look at which ones can we retain, which ones can we add to make South Africa attractive for those tourists and also businesses. And then in H, they indicate that the foreigners' full details, records, fingerprints must be enforced. Our response is as follows, Chairperson. As I indicated, we indicate that the input that's been received from NAFCOC can be best dealt with in the supplementary paper, as some of the suggestions are outside the scope of the bill. And then in B, we indicate that the insertion of a requirement of a conditional acquisition of property falls outside the scope of the bill, and the same is, however, noted. And then on the next page, in slide number 20, it's a submission that we have received from Scalabrini Center of Cape Town. They indicate, Chairperson, that they agree with many of the bill's provisions, particularly those ensuring timely access to court and limiting detention to instances where it is in the interest of justice. The amendments, according to Scalabrini, will go a long way towards improving Section 34, and by and large in keeping with the direction set by the Constitutional Court. In B, they indicate that they make the following recommendations: that Section 34(1) be amended as follows, and they indicate that without the need for a warrant, an immigration officer may arrest an illegal foreigner or cause him or her to be arrested, provided that the officer ensures that those that fall under the refugee definition, stateless persons and survivors of human trafficking, are released and are referred to where it is appropriate. They further indicate that the immigration officer shall, for those not in any of these categories, irrespective of whether such a foreigner is arrested, deport him or her or cause him or her to be deported, and may, pending his or her deportation, detain him or her or cause him to be detained in a manner and at a place as determined by the Director General, provided that the foreigner consent. And then in C, there's a recommendation that they are making. A new provision should read Section 34(1) capital AH, and they recommend that when existing discretion to release under subsection A, C, and E, discretion should be, in so far as possible, exercise in favor of freedom. And then in D, they indicate that it will also be important to ensure that provisions in the regulation in relation to Section 34 carry through to protect children from being held in immigration, detention, or deportation. It's similarly to what the center at Pretoria made that recommendation. Our responses are as follows, Chair. One, we submit as the department that the asylum seekers or refugees are not subject to detention unless under the circumstances tabulated in sections 28, 29, and 36 of the Refugees Act of 1998. Secondly, we submit that the determination to either detain or release any person of interest is as guided by the judgment, but also in line with provisions of sections, again, 32, 34, and 41 of the Immigration Act. We wish to reiterate again, Chairperson, that the department, that children are not detained. And then the next comment, as we move towards the end, Chair, is from the South African Human Rights Commission, which recommends that Section 35 of the Constitution highlight the rights of detained persons, and therefore the umbrella of rights must be reflected in Section 34 of the bill. The Human Rights Commission further indicates that the suggested all-encompassing provisions will ensure that the DHA does not further face litigation as it relates to 35 of the Section 35 of the Constitution. They are of the view or suggesting that Section 34 could read as follows, that it shall be informed upon arrest or immediately thereafter of the rights set out in the Constitution, close quote. And then in B, they then indicate that the bill in its current state does not provide for unconditional release when a detention is unlawful. It is on this basis that the suggestion above is made. Further, the Human Rights Commission has made the two recommendations for consideration. The first one, Chair, is the extension of submission deadline to be the 14th of February 2025. The second one is to ensure that Section 34 reads as follows: shall be, open quote, informed upon or immediately thereafter of the rights set out in Section 35 of the Constitution, close quote. Our response is as follows. We confirm that Clause 1B of the bill provides for the submission that a detained person must be informed of his or her rights as contemplated in Section 35 of the Constitution. And then in B, Chair, we then say it may be impractical to release an illegal foreigner without setting conditions for his or her release. In essence, releasing an illegal foreigner unconditionally will be defeating the very spirit and purport and object of the Immigration Act of 2002. And then on slide number 22, it's a submission by the United Nations High Commissioner for Refugees. The UNHCR notes the lack of explicit definitions of key terms in Section 1 of the Immigration Act and recommends insertion of certain definition in Section 1. Further, the UNHCR recommends, Chair, the substitution of terms and definitions already found in Section 1 of the Principal Act. And then in its oral submission, UNHCR also implored the Portfolio Committee to consider alternatives to detention. Our responses are as follows, Chairperson. One, we indicate that the suggested definitions should be considered as we recommend in the supplementary policy work on immigration matters. However, it's important to point out, Chair, that Section 1 of the Immigration Act contains a definition of an illegal foreigner. Further, other pieces of legislation in the Republic refers and uses the term illegal foreigner. In B, we then indicate that the question whether or not to delete, alternatively, not to use the definitions or terms as suggested. Again, we recommend that it's best dealt with during the white paper process or the supplementary paper. And then on alternatives to detention, our view as a department is that this requires policy decisions, and it's something that we can deal with as we develop the white paper or the supplementary paper as directed by Cabinet Chair. Now, there's a detailed report on the written submissions that we have also shared with the committee that responds to almost all the submissions. It's quite detailed. And then on slide number 24, it is therefore recommended, Chair, that the Portfolio Committee notes the responses that we are providing as the department in relation to the submissions, written, oral, received from the public participation process on the bill. Thank you so much, Chairperson.
Thank you very much, DG, for detailed brief. I'm sure that Mr. Advocate Malekate will participate on the responses from the department. I'm not sure whether what was the technical issue in his gadgets. We'll now invite the Parliamentary Legal Services to present. Thereafter, we'll invite members to comment on the two presentations.
Good afternoon, Chairperson. This is Daksha Kassan. I'm from Legal Services, and I have with me Ms. Clara Williams, who is assisting me on this bill and will also assist in fielding any questions after this presentation. I think everyone has sight of the presentation. I see it here on my slide, so I'm going to proceed to the next slide. Chairperson, in preparing this presentation, we looked at the immigration bill itself as introduced, all the submissions that were submitted to the committee, as well as the analysis of the submissions which were prepared and presented by Adam Salmon. And we also considered the oral submissions that were presented to this committee during February. And after doing so, we identified the legal and constitutional concerns raised in these submissions. And hence the purpose of our presentation is to focus only on these legal and constitutional concerns. Policy issues have been left to the executive to address. Next slide. Chair, I'm going to skip this slide because the department has comprehensively articulated the findings of the two Constitutional Court judgments. So I really don't want to repeat that for the sake of time. But having said that, the department coherently presented the findings of both the 2017 judgment as well as the 2023 judgment and articulated the remedy that the Constitutional Court had provided, which remedy would apply to all illegal foreigners during the suspended period as well as after. That remedy is largely reflected in the bill as introduced. However, we would just like to reiterate at this point that the Constitutional Court has confirmed that the domain to amend any legislation is the prerogative of Parliament. It's not for the courts to do. As Parliament is considered best placed to remedy the problem or the constitutional defect, and both judgments had enabled Parliament to correct the defect. As we heard, the 2023 supplementary order also introduced the concept of interest of justice, and it made the order that any detailed illegal foreigner must be brought before court within 48 hours after arrest, and then if that detention is to proceed for longer than 30 days, the person must then be brought before court again to determine whether the 30 days can then be extended to 90 days. Now, the manner in which the order was crafted, the court expressly stated that the order provides appropriate guidance to address the unconstitutionality in the Act, but it did so without affecting the separation of powers doctrine, as they are aware that there's a range of possibilities that the legislature may adopt to cure unconstitutionality. And we just thought we needed to make this point clear to the committee in the event that the committee would want to go beyond the scope of the judgment. Having said that, the bill which has been introduced seeks to address these constitutional judgments. It was advertised for public comments and numerous written and oral submissions were received. The comments received straddled both policy and law relating firstly directly to the content of the bill. However, some comments received are also general in nature, referring to the immigration system at large. As stated before, however, our presentation will only focus on the legal and constitutional issues raised in respect of the content of this bill. The first theme I'd like to touch on is the issue of terminology. As the department has indicated, there have been submissions made that the term illegal foreigner should be changed either to non-national, undocumented person or irregular foreigner, for reasons that the term illegal foreigner carries negative connotations that can fuel stigmatization, discrimination, and violation of human rights. There have also been submissions made that the word deportation should be changed to removal. There have been numerous submissions made in respect of new terms that should be defined in the bill. These include asylum, asylum seeker, detention, deprivation of liberty, diplomatic asylum, and I've listed many more over there. There's also been submissions that terms relating to children in particular should be included in the bill. Now, as the department has indicated, the change in any terminology, as well as the inclusion of other definitions, is largely a policy decision, and the department has said that they intend to address these issues in the supplementary work that's being done on the white paper. But in the event that this committee takes a decision after its deliberations that certain new terms should be defined, we just wanted to alert the committee to certain drafting conventions in relation to that. The first is that only words used in an act should be defined. Now, a lot of the words that were suggested in the submissions are not found in the act, nor are they found in the bill. And in brackets there, I have a list of the definitions that have been suggested by submitters, but are not in the act, nor are they in the bill. Other words suggested are actually used in the Immigration Act, but they're not defined in the Immigration Act, but are rather defined in the Refugee Act. And those in particular are words like asylum seeker and refugees. The second principle to note is that only words used in the bill and to which a specific meaning other than a normal dictionary meaning is ascribed need to be defined. So those were the two drafting conventions that we wanted to just alert the committee of. And if terminology is changed, it may necessitate further consequential amendments to other provisions of the Act, as well as to other pieces of legislation. And we would say that the department is best placed to advise as to what these consequential amendments would be. Moving on, the department also presented that a lot of submissions were received, especially in relation to children. The nature of the submissions were that there are a wide range of child migrants who lack proper documentation, and they are then automatically considered as illegal foreigners and are arrested and detained in facilities that are not appropriate for children. Some of them are placed with adults or treated in a manner in conflict with the constitutional and international obligations. There were also submissions made that unaccompanied minors should not be arrested, but they need to be placed in a shelter and dealt with in terms of the Children's Act as a child in need of care, particularly in relation to children. Detention should only be as a measure of last resort and for the shortest possible appropriate time. Some submitters have said that the bill should, similarly to the Refugees Act, contain provisions relating to unaccompanied migrant children, but currently the bill nor the Act does not do that. Age determinations should also be undertaken in certain instances where there is uncertainty as to whether a person is a child or not, and that the department should take on a child-centered approach when dealing with irregular minor children, and that at all times their rights entrenched in Section 28 of the Constitution should be protected. Now, Section 28 of the Constitution provides special protections for children. And I want to stress here that those protections are not limited to a South African child who is a citizen. It is extended to every child who is found within the Republic. Section 28 also defines a child as a person under the age of 18 years. And then there are numerous rights entrenched in Section 28, which range from the right to basic nutrition, health care, the right not to be detained except as a measure of last resort, and when detained, to be detained only for the shortest appropriate time, and to be kept separately from from adults who are detained. Now, when we looked at the Immigration Act, we noted that the Immigration Act does include the term child in various sections, but it does not define the term child. So in other words, While the Act uses the word child, it does not say that a child means a person under the age of 18. The Immigration Act also uses the word minor in various sections, which term is also not defined, and it appears to us that the Act uses these terms, namely child and minor, interchangeably. In one section of the Act, a child is referred to as a child under the age of 21, which does then not align with Section 28 of the Constitution. The Immigration Act, we noted, also does not expressly state how unaccompanied migrant children should be managed, nor does it expressly provide that detention of children be a measure of last resort and that children be detained for the shortest appropriate period of time and separately from adults. Now, we noted the department has said that the SOPs address the issue of children, and in terms of the SOPs, children are not detained and they are kept separate from adults. However, our recommendations would be that in order to align with Section 28 of the Constitution, where children are specifically protected, that the bill include a definition for child to provide certainty as to who a child is, that the issue of whether minor intends to mean child be cleared up by the department and the Act be amended or cleaned up accordingly, that the bill, similarly to the Refugees Act, expressly provide for how unaccompanied migrant children should be managed and treated as a child in need of care. What appears in blue on the slide is the section found in the Refugees Act, which specifically provides for the protection of unaccompanied children and specifically says that such children must be treated as a child in need of care as contemplated in the Children's Act. Now, should this committee agree that an express provision be added into the bill, then we would recommend that something along these lines be included in the bill. We also submit that the bill expressly provide that the detention of a child be used as a measure of last resort and that they be detained for the shortest appropriate period of time, also again separately from adults. What we do there in blue is we quote the wording of what is currently found in Section 29(2) of the Refugees Act, which provides that the detention of a child must be used as a measure of last resort for the shortest possible period of time, taking into consideration the principle of family unity and the best interest of the child. Then there were many submissions made regarding other categories, or rather special categories of foreigners, as we put it. These include refugees, asylum seekers, stateless persons, and survivors of human trafficking. The submission there was that these categories of foreigners should be protected from being arrested, detained, and deported in terms of Section 24. Submitters made us aware of the Section 21(4) of the Refugees Act, which states that no proceedings may be instituted against any person who has illegally entered the country if he has applied for asylum. They said that the bill does not provide for the protection of stateless persons, and there was a lot of submissions also made about the rights of persons from the LGBTI communities. Now, in a meeting held with officials from the department explained to us that if during the Section 41 interview, it is clear that the person is an asylum seeker, a refugee, or victim of trafficking, then such persons are not detained in terms of Section 34 of the Immigration Act. Instead, such persons are referred appropriately to receive the necessary assistance and dealt with in accordance with the applicable laws, like, for example, the Trafficking Act. And we submit that the submissions made in respect of the LGBTI persons is a policy decision for this committee to consider in line together with the department. Moving on to Section 35(2) rights, there were submissions that the bill states that a detainee must be informed of all the rights contained in Section 35, that the bill should reflect the wording of the entire Section 35 rights. there were submissions made in respect of access to legal representation, where it was said that legal representation in deportation matters is limited to those with financial means, or the few that are assisted by law clinics or civil society, and that persons arrested for deportation should have access to free and affordable legal representation, that state-funded legal aid is generally absent in these matters, and that the legal aid manual must be amended to allow for representation of persons in civil proceedings. Still on the Section 35's rights, a lot was also said that access to interpreters must be enhanced and access to language services must be enhanced, as detainees must understand their rights and effectively participate in legal proceedings. There was also submissions made that such illegal foreigners who are detained must have access to information in a language that the foreigner understands and comprehends. And there were submissions made that the bill in its current form waters down this right to information in a language that the detaining understands by including the caveat in the bill. In other words, the right to have information is joined with this caveat when possible, practical, and available, and that these words then should be deleted. With regard to unconditional release, there were submissions made that the bill does not provide for this. Now, without wanting to repeat too much of what was said by the department on the findings of the judgments, I just want to once again highlight these points. In the 2017 judgment, the court said that the Section 34 does not require a detainee to be informed of all the rights enumerated, particularly in Section 35(2), apart from being told of the reason of the decision. The Constitutional Court noted that Section 35(2) also requires that a detainee be informed of his or her right to legal representation by a lawyer of his or her own choice, and then also to be assigned one at state expense if substantial injustice would otherwise result. The court also found that the section did not require automatic judicial review. The court found that the provision does not allow the detainee to make any representations to the court, either orally or in writing, and it allowed for detention to continue for at least 48 hours before the detainee was brought to court. The court also said that the section did not allow the detainee to make any representations to court. Now, it is noted respectfully that the bill does not contain a reference to all the Section 35(2) rights of the Constitution, and nor does it contain all the findings of the 2017 judgment. So what we do in the next few slides, Chairperson, is that on the left-hand side, we note the current Section 35(2) rights of the Constitution, and in the right-hand column, we state whether that particular right is reflected in the bill or not. So the first right in Section 35(2) is in 35(2) paragraph A, which says that every detained person has the right to be informed promptly of the reason for being detained. When we looked at the bill, we see that the bill only provides that the foreigner be notified in writing of the decision to deport him or her. It does not say that he must be informed of the reason for his detention. The bill provides that he be informed of the right to appeal, and then the bill provides that the detainee must be informed of the opportunity to make representations. Now, we've included the provision of Section 35(4) there in point 2 in the left-hand side, where the Constitution says, whenever this section requires information to be given to a person, that information must be given in a language that the person understands. Now, as I mentioned earlier, the current wording in the bill where this right is reflected also has the words when possible, practical, and available. And we submit that the words underlined waters down the right as expressed in section 35(4). The next right in section 35 is found in paragraph B, where it says that the detained person has the right to choose and to consult with the legal practitioner and be informed of this right properly. Our submission is that the bill does not place an obligation on anybody to inform the detainee of this right. And this was particularly highlighted in paragraph 51 of the 2017 judgment. Again, when being informed of this right, it must be in a language that the person understands. And I'm not going to then repeat what I said earlier, that currently it's the words when possible, practical, and available seems to water down this right. The next right is in 35(2)(c), which is the right to have a legal practitioner assigned to the detained person. And the detainee must be informed of this right if substantial injustice would otherwise result, and to be informed of this right promptly. Again, we submit that the bill does not place such an obligation for the detainee to be informed of this right. Then in 35(2)(d), the detainee must be given a chance to challenge the lawfulness of the detention in person. We submit that the bill does provide for this. It provides for the person to be brought before court in person within the first 48 hours, and then also for every time that the detention is considered for extension. The right also includes, that if the detention is unlawful, that the detainee must be released. The bill now provides that the immigration officer and the court must consider whether the interest of justice permits the person's release. So we submit that it is actually contained in the bill. On the next slide, the other rights contained in section 35(2) are the right to conditions of detention that must be consistent with human dignity, including at least the provision of exercise at state expense, provision of accommodation, nutrition. This is not in the bill, but we do note that the minimum prescribed standards, that the minister has the right to prescribe minimum standards, and these are contained in the department's regulations or standards, and the department is best placed to confirm that the detention is consistent with these rights. The other right is that the detainee must have the right to communicate with and be visited by his spouse or partner, religious counselor, and so forth. Again, this is not in the bill, but the department is to confirm if this is allowed in practice. We are not saying that these last two rights need to be placed in the bill, but as long as the detention is in humane circumstances and that the detainee is granted these rights, that would suffice. As noted earlier, the court did say that the detainee must have the right to make representations to court, either orally or in writing. The bill now does provide for this, but it does not expressly specify that those representations may be oral or written. And then another finding was to allow for judicial review upon arrest and also before any extension of further detention, and we submit that the bill does provide for this. So what we're saying is that the table above reflects where the bill is lacking in respect of some of the Constitutional Court's findings, and we would recommend that the bill be amended accordingly to incorporate these findings. With regard to access to legal representation and state-funded legal aid, again, in our meeting with the department's officials, they confirmed that detained persons are allowed to consult with their legal representatives. They said that state-funded legal representation is catered for via legal aid, and as per the Constitution, should be assigned in instances where substantial injustice would result. The department also indicated to us that courts often adjourn in matters where state-funded legal representation is requested. And again, the department is best placed to attest what the situation in respect of state-funded legal representation in Section 34 detentions are. With the Section 35(4) right, that all information must be provided in a language that the person understands, we noted earlier on that the bill includes the caveat where possible, practical, and available. We note that Section 36 of the Constitution does allow for the limitation of these rights. In our meeting, the department indicated to us that deleting these words will have huge financial implications. However, we'd like to alert this committee that it must be noted that the Constitutional Court has expressed that costs alone as a justification cannot be a reasonable and justification limitation of a right. With regard to unconditional release, the department has indicated that this would be impractical. There would not be any capacity to monitor illegal foreigners, and that they would address this in the supplementary work being undertaken by the department. Moving on, as the department indicated, the 2023 judgment introduced the interest of justice standard. There were submissions made that this phrase is way too broad and it can be applied subjectively, and it's very inflexible and can be applied in various ways. They also said that the term fails to provide the necessary guidance to ensure the discretionary power it grants is exercised in a manner that aligns with the protections of the Bill of Rights. They said that legislation must provide clear guidelines to ensure that any limitations on the rights are justifiable. A clear definition must be provided, and clear and equitable criteria for interest of justice assessments must be developed. Now, when we look to see what this legal standard is, we came across the Dlamini judgment, which was particularly in regard to bail proceedings. The court said that the interest of justice, it's a legal standard which is a useful term denoting in broad and evocative language a value judgment of what would be fair and just to all concerned. It entails an overall evaluation of all the interests involved. It's a legal standard which evaluates whether actions taken in a case serve the fair administration of justice. In bail proceedings particularly, it involves a weighing up of interest of the accused in liberty against those factors which suggest that bail be refused. Now, the term interest of justice is found in many sections of the Constitution. In Section 5, in respect of it, in Section 35, 1 paragraph F, in respect of arrested persons, in Section 80 and 122 in relation to an application to declare an act constitutional, and then I've mentioned the other sections there as well. For the sake of time, I'll not go through them. And when we looked at our legislation, we found that the term is used in a range of South African legislation, ranging from the Criminal Procedure Act, the Child Justice Act, the Domestic Violence Act, and many, many more. Now, what the court said in the 2023 judgment is that while the interest of justice criterion is well known in our law, the courts have confirmed that because of its breadth and adaptability, it is prone to imprecise understanding and inapposite use. It does create the risk of uneven application. In the 2023 judgment, the court also acknowledged that not every decision maker under Section 34(1) will be a judicial officer, and said that for the immigration officer in particular, an interest of justice test may well present interpretive challenges. Now, bearing that in mind, it is our recommendation that factors to assist an immigration officer or a court to consider whether the interest of justice permit the release of a person detained should be provided in the Act. And here we want to just refer the committee to examples in Section 60 of the Criminal Procedure Act, as well as Section 24 of the Child Justice Act, where both pieces of legislation list particular factors to assist any official or the court to determine what might be in the interest of justice. And we would say here that the department, given their expertise and knowledge of the operations on the ground, is best placed to assist this committee in developing those factors. There was also submission made that an extension of the court deadline, which was last year in October, be sought, given the order that the court had given. Chair, in our response, this committee will recall that on the 20th of August, our office briefed this committee on an opinion as to why it was not deemed necessary for Parliament to approach the Constitutional Court for an extension. Without going into too much detail, we had presented to this committee that the reasons why we thought it was not necessary for Parliament to approach the court for an extension was because there was no new declaration of any invalidity of any of the provisions, coupled with any new suspended order. The impugned provisions, namely Section 34(1)(b) and D, are no longer part of the Immigration Act, given that the suspension period in the 2017 order had already lapsed. The 2023 order provides a remedy that applied during the 12-month period after the order, as well as that remedy would apply beyond the 12 months. So currently, that remedy that the court handed down currently applies, and that there would therefore be no gap in the law. And currently, Parliament is in the process of processing the bill, which addresses the judgments. I'm not going to deal with this slide. The department has already dealt with this. So I'm going to just skip to the next. Chair, what we'd just like to remind the committee of is our NA rule that says that should this committee wish to amend any other provisions of the Immigration Act, that permission of the Assembly will first need to be sought. So following deliberations, if there is a need to amend any other provision of the Act, we want to alert the committee to this particular rule. And then should there be any new substantive amendments made to the bill, which constitute an amendment, a material amendment, we just want to remind the committee that such amendment will then again have to be advertised if it was not within the domain of the public. Thank you, Chair. That concludes our presentation.
Thank you very much for the detailed presentation and comments on the process for public comments or oral submissions that we made. I will invite the Chief State Law Advisor, Ms. Govender, to comment. Then I will invite members to make or to raise questions or comment on the three presentations that will be been placed before the committee. Ms. Govender.
Good afternoon, Honorable Chair and Honorable Members. Greetings to the Deputy Minister, the Director General, and all stakeholders. Thank you, Honorable Chairperson and the committee, for allowing us, as the Office of the Chief State Law Advisor, to contribute to this afternoon's proceedings. We promise to be quite brief. Chairperson and Honorable Members, the Office of the Chief State Law Advisor certified the Immigration Amendment Bill B8 of 2024 during the course of last year. After having thoroughly studied the judgments in the matter, that's the 2017 and 2023 Constitutional Court judgments, we also considered the Constitution as well as the other legislative instruments that were relative or were relating to the particular order that was granted by the Constitutional Court. Chairperson, we certified the bill as constitutional, and we found that the bill provided sufficiently for what the judgment had required, in terms of what the Constitution required, as well as from a drafting perspective. And we were satisfied that the bill in that form would meet constitutional muster. Chairperson, that being said, we have thoroughly considered all the public comments that were received. We have also considered the presentations that have been made by the department, as well as that was just presented by the Parliamentary Legal Services. Chairperson, we stand by the fact that the bill in its current form, which is derived from the order of the Constitutional Court, sufficiently covers the aspects that were raised. And our views in this regard are aligned to the Department of Home Affairs in respect of the following main issues. Chairperson, with regard to the interest of justice criterion, Parliamentary Legal Services has correctly quoted from the 2023 Constitutional Court judgment, where reference was made to the case of S versus Dlamini. Also, however, in addition to that quotation, at paragraph 52 of the 2023 judgment, the court said that while the interest of justice standard does create the risk of unequal application, any rule conferring discretion to the decision maker would be vulnerable to this criticism. at least, and I think here this is where the Honorable Roos previously mentioned, the interest of justice is a standard drawn directly from the Constitution. Further, in the 2017 judgment, where the court looked at the Dawood case, where in that particular matter, the powers of the immigration officer were given without any guidelines, the court said guidance will be required to ensure that the Constitution takes root in the daily practice of governance. Where necessary, such guidance must be given. Guidance could be provided either in the legislation itself or, where appropriate, by a legislative requirement that delegated legislation be properly enacted by a competent authority. That's from paragraph 49 of the 2017 judgment. Chairperson, the department has indicated that such guidance will indeed be provided when the immigration officers are in fact implementing this interest of justice criterion. Further, clause 1 of the bill, specifically paragraph C, provides in the proposed section 1A(c) that the court before whom the detained foreigner is brought must consider whether the interests of justice permit the release of such person subject to reasonable conditions, and must, if so concludes, order the person to be released subject to reasonable conditions. So we submit in this regard that it's also the court that will be applying this interest of justice criterion, and we submit that this is indeed sufficient. Chairperson, with regard to the aspects surrounding children, it has been presented that the importance with regard to the importance of children's rights being of paramount importance as provided for in Section 28 of the Constitution. And upon analyzing the Immigration Act itself, as well as the Constitution, and more specifically Section 28, we've also considered the Children's Act and Child Justice Act, amongst others. And it is submitted that there appears to be sufficient protection against the exercise of authority, which is against exercise of authority involving children. We feel that it is sufficiently catered for also the wording in Section 28(1)(g) of the Constitution, which provides that every child has the right not to be detained except as a measure of last resort, in which case, in addition to the rights a child enjoys under Section 12 and 35, the child may be detained only for the shortest appropriate period of time and has the right to be...
Sorry, Governor.
Yes, Chairperson?
Sorry to interrupt you. Do you have a presentation if we can flag it for the purpose of the public? Or those that are following up the... But if you have not prepared it, it's fine. I just want to ask you.
Chairperson, unfortunately, we do not have. We're just responding to the presentations that were made. However, should the committee require us to present something that could possibly be shared to the members, we can do that, Chairperson.
Yeah, okay, proper. Then you can proceed.
Thank you, Chairperson. Just to carry on from 28(1)(g), not to be detained, and also that is to be kept separately from detained persons over the age of 18, and to be treated in a manner and kept in conditions that take account of the child's age. Chairperson, we feel that that constitutional provision, together with the provisions in the Children's Act, which was mentioned earlier by the department, such as Section 150, as well as the provision of the Child Justice Act, render this protection to children sufficiently covered, and it would not be necessary to restate all these provisions in the bill. Chairperson, further, Section 34(1)(e) of the Immigration Act, which has not been affected by the bill, specifically states in relation to the foreigner concerned in Section 34(1) that that person shall be held in detention in compliance with minimum prescribed standards protecting his or her dignity and relevant human rights. And we submit, Chairperson, that this covers these categories of people, including children, that they are in fact given all this protection by virtue of this provision in the Immigration Act. The second to last issue that I would just like to discuss is with regard to the rights applicable to the person envisioned in Section 34 of the Immigration Act, more specifically the Section 35(2) rights. Chairperson, in the 2017 judgment at paragraph 41, the rights in Section 35(2) of the Constitution were listed, and in paragraph 42, it was said that in plain language, this section applies to illegal foreigners detained in terms of Section 34(1) of the Immigration Act. And then the court then went on to specify those specific rights that are applicable. Also, Chairperson, the Constitution itself in Section 35, and more specifically Section 35, which has the title Arrested, Detained, and Accused Persons, and more specifically 35(2) of the Constitution provides that everyone who is detained, including every sentenced prisoner, and it lists the rights that a detained person does have. And we feel that this also is sufficiently covered in respect of what is provided for in the bill, and it does not need to be restated in the bill. And finally, Chairperson, with regards to the wording that is used in Section 34(1)(c) of the Immigration Act, in respect of the language and the specific wording of when possible, practicable, and available in a language that the person particularly understands. Chairperson, we submit that this was not an insertion in the bill, but it was in the Act when the Act came into operation in 2002. And as far as we have ascertained, these wordings have not been challenged. So we therefore submit that it's not being watered down in the bill, as it has existed in the Act and it has not been challenged. It has also not been amended, even though the section of 34 had been amended. This particular wording has not been amended. And we submit that based on the meanings of those words, it's to show that these language rights are protected, obviously, but it still involves a balancing out of the principles of the right that they have, that the foreigner may have, to the practicability of the principle. And obviously, the department has a duty to ensure that all reasonable steps are taken to make these rights to translation and interpretation facilities available within the adequate and financially sustainable basis and grounds that do exist. Chairperson, those were just our submissions based on the public comments as well as the presentations that were made. As advised, we will put this in writing and circulate it to the committee as required. Thank you, Chair.
Thank you very much, Ms. Governor. When possibly can you circulate the response that you have just made to the committee so that we are clear the process? Yeah,
we can possibly later this afternoon. I could have it by this afternoon if that's suitable.
Okay, no, it's fine. Yeah, that will assist the members. You can circulate, and on Tuesday, if there are issues to deal with, at least we will be running from the 3 presentations. Members, I'm now inviting you to comment on the 3 presentations, noting that Ms. Govender, she has still to circulate, but I think we might have covered some of the issues. Mr. Matwentu will assist me to note members. I see the hand of Honorable Machi, Honorable Rose, Honorable Ngubane. Yeah, let's start with Honorable Machi. Can you proceed?
Thank you very much, Chairperson. Firstly, Chairperson, I'm also of the view that these rights should be minimized. So there will be a need of rights limit. Okay, Chairperson, let me just go straight to the detention as the last resort, as it has been said there. Given that the Constitution provides that the detention of children should be a last resort, what monitoring mechanisms are in place to ensure that this principle is upheld in practice? Secondly, how does the department ensure that immigration officials and law enforcement agencies are adequately trained to identify and handle unaccompanied migrant children as children in the need of care under the Children's Act? Thirdly, what measures have been put in place to prevent the detention of children in appropriate or harmful conditions? Thank you, Chairperson, for now.
Thank you, Honorable Machi. Honorable Ruas.
Thank you, Chair. And let me start by thanking all the stakeholders that presented today for providing considered reports on the submissions. I think it's critical. Public participation is one of the most important tools in Parliament to make sure that Parliament is for the people. And really, I think that justice has been done to all the submissions that have been made. Chair, I want to start with, again, reinforcing the underlying principle that we deal with the requirements of the judgment and then save other inputs on general immigration law matters for the review process that has started with the white paper and the submission on that. So I think there were a lot of inputs that are related for that, and that includes the challenge with statelessness, where we discussed at length how do we determine statelessness in the necessary amount of time, as well as dealing with issues of the recognition of LGBTQI in the refugee and the asylum seeker process. Chair, I want to start with the DHA, and the DHA mentions a standing operating procedure quite a lot. I want to understand, they say that children are placed at places of safety through the Department of Social Development. What happens with babies in this case, and mothers with babies, brand new babies? Then DHA seems to be relying quite a lot on the standard operating procedure document, but we haven't seen it, Chair, and I think it's difficult for us to accept that it covers things adequately. So I would request that we receive a copy of this SOP before our next deliberations on this matter, so that we can satisfy ourselves that it adequately covers the concerns raised. Then, Chair, I don't want to pit the Parliamentary Legal Services and the State Law Advisor against each other, but Parliamentary Legal gave us some inputs and recommendations about including definitions and clauses for children and minors. And the State Law Advisor, if I understood it correctly, was saying that it's not necessary as it's covered in other legislation. I just want to get the feedback of Parliamentary Legal. And again, this is all an interpretation. Do they agree then with that interpretation of the State Law Advisor that these specific clauses about children and minors are not needed? Is there any, I guess I could call it a counter argument? Then Parliamentary Legal Services, I had a concern about the different factors that constitute the interests of justice. And I spoke in the last meeting about the magistracy and how, sometimes you will get an acting magistrate, etc., that might be a practicing attorney. So, I would submit that it is critical that we do put out these factors that constitute the interest of justice properly and carefully, so that they're very clear. So I welcome the input that the Department of Home Affairs can give us inputs on that based on their experiences. But my question is, would those experiences cover everything? Because we have the DHA in terms of arresting, let's call them illegal foreigners for the sake of what the definition is in the Act. But then we also have the legal process that then runs. So is it sufficient to just have the department giving the inputs on this, or do we also need to consider things like the Criminal Procedure Act and what that gives as the interest of justice, so that we can get a holistic view as a committee of interests of justice from the perspective of the Department of Home Affairs, but also from the justice system? So if we can just get input from Parliamentary Legal on that. Then a further question in this: if we had to include these interest of justice criteria, would it constitute a substantive change to the legislation that would require an extended public participation process? And then the final question is just, if you look at the Constitution, it talks about, Section 35(3)(k) talks about the right to a trial in a language that the litigant understands, or the accused, I suppose, and the right to have an interpreter. And then Section 6 of the Constitution recognizes 11 official languages. So I just want to get an interpretation of that. So Section 9 also talks about prevention of discrimination based on language. So are those constitutional provisions based on the 11 official languages? And this would include sign language now, by the way. Or does it include any language that any foreigner could possibly have? Because there are massive cost implications in terms of, having this. So it's fine if you have to be informed in a language, but then you have to cover every single language that could possibly be on the planet Earth. But then it goes further in terms of saying you need an interpreter in court and in the legal system. And how would this practically be implemented, given that the accused needs to appear in court within 48 hours? So if I could just get an interpretation from both, the state law advisor and parliamentary legal in terms of those constitutional provisions, do they apply to the 11 official languages and sign language, or to any possible language under the sun? Thank you, Chair.
Thank you very much, Honorable Ross. Honorable Ngubane.
No, thank you very much, Chair, as well. We appreciate the presentation. Mostly it covers most of the things. But Chair, what I would like to know as well, as an advice from the Home Affairs and these legal advisors that are here, is there a way in the bill where we accommodate the country responsible for the people of immigrant to take some level of responsibility as well, or penalty, if the immigrants came to the country as well, to try and alleviate some of the burden and cost that needs to be carried by the country South Africa? Is there a way to try and put that legally? That's just the question from my side, Chair. And then the second one, Chair, again, we see it's just one line, but it's very much weighty, where it says the department doesn't have a capacity to monitor illegal foreigners. So we have a problem, Chair. The department must just try and up its game. In the country, we have a lot of illegal foreigners running amok, untraceable. No one knows their name. They're creating the crime rate that we have that is higher. I'm not generalizing in this statement, but most of it in the Diepsloot and everywhere, matters are happening, and no one is able to take account for that. These people are untraceable, they are unidentifiable. Is there a way as well, if the DG or the Deputy Minister, they must give us comfort as well that there is some level of improvement to try and have a capacity to monitor these illegal foreigners? Because a lot of these legalities that we're going through to the court is because of the department not having sufficient capacity or skills to do its work to alleviate issues, even to implement proper processes and laws of these immigrants and taking care of everything. Cutting corners, which is what makes the department has a lot of cost incurred through court. If the department can try and improve on that one, and must not always say, I don't have a capacity to do this, I don't have the skills to do this, I don't have a strength to carry this. If we can try and monitor as well from our side those shortcomings. Thank you, Chair.
Thank you very much, Honorable Ngubane. Honorable Mutambi.
Thank you, Chairperson, and thanks to all the presenters. Let me join the colleagues who have welcomed the presentations. I think this will assist us a great deal, Chair, as we deliberate on these matters. Hence, the input of the state law advisor must be provided to us. having said that, I want to also echo the sentiments of Honorable Ross in some aspects. Because whatever we do, Chair, maybe I'll ask this simply to the department and the parliamentary state law advisor. You have just passed the budget. I think it's 2 days ago. And whatever we do, the financial implication of the legislation, this legislation to our already physical constraints that we face as a country. I'm raising this because, Chairperson, maybe I would like to get the comment of the department and the legal service of parliament. The legal aid board is governed by the act, and then there are instances which one, even in the country for the resident, a citizen, it doesn't cover. And then now, if we are to extend this issue of legal, I've seen the recommendation here to foreigners to have the rights to legal representation. Can we then talk to it, linking it to the limitation of the rights? Because I understand what the court was saying, but also, the issue around legal representation, there are matters which also on the state-funded legal aid, the legal aid don't cover for South Africans. Also, the issue of language. I don't think even all languages in the country, there are documents that we don't publish them in all the recognized languages, including the sign language that is here now again. But then if we are to give effect to this, also to look at the situation that is happening in the country, how are we going to balance this? So these are some of my concerns here. But nevertheless, I should think as and when we deliberate of the matters, we'll have to look at all this submission, and then I think they assist a lot, and one would like to thank the team for that. Thank you, Chair, for the opportunity.
Thank you very much, Honorable Mutambi. Honorable Mukhale.
Thank you very much, Chairperson. Let me also take this opportunity to appreciate the presentations. Chair, I just have one or two questions on the presentation. Just need clarity on this, and I think the department must provide clarity to us. What is meant exactly by reasonable conditions? Under what reasonable conditions will an illegal immigrant be released? And also to clarify exactly what is meant in the Act by in the interest of justice. I think the presentation by the Parliamentary Legal Service also touched on that a little bit. So I would like to hear the department deal with those two issues. Thank you, Chair.
Thank you very much, Honorable Mukhale. Honorable Matapa.
Thank you very much, Chair. Let me also take this opportunity to appreciate the presentations. Chair, I'm partially covered by Honorable Ross and Honorable Mohale. Honorable Ross on the child effect, what happens if the child is a baby? And on the reasonable conditions as well, Honorable Mohale covered me. However, Chair, I want to come to the basic reality on the ground. Layman language from a person who's sitting there and who's directly affected by the influx of foreigners in our country. And not forgetting that, we as the Patriotic Alliance, we really have a strong view on illegal immigrants. Yoguti, mabahambe, bamoshile che, basaqhubeka. So what I'm saying is, from a layman, it sounds as if illegal immigrants, whether it's asylum seekers, they've got more rights than South Africans. And then, you know, Chair, we should acknowledge the laws and the constitutions of this country. However, as I'm saying, if a situation is not directly affecting you or your livelihood, it looks as if we are less interested on things that are affecting our people on the ground. And looking at the crime rate, the drugs, etc., it looks like we as a country has lost control over our country. Coming to, I've got two questions that I would like to ask, Chair. And also with the marriages, what is the department doing currently? What corrective measures are there to remedy the damaged surnames already impacting the daily lives of our people and their families? As we all know, there's a show which shows people were married under the pretext of giving them employment and so forth. And also the asylum seekers. It is mentioned that no proceedings may be instituted against any person who has illegally entered the country if he has applied for an asylum seeker or been granted asylum seeker. Now, if a person has applied for asylum seeker, how did they enter this country when they have to be in South Africa and then apply for this asylum seeker? Now, it looks like we need to negotiate with people who are illegally in our country, of which, yes, also acknowledging their human rights. But how did they get into our country? And the other question would be, how does the bill plan to address the economic impact of immigration on local workers and businesses? Second question would be, in the Tuesday meeting, a question was raised by one of the honorables to say, what is the department doing with the illegal immigrants already in this country? And the answer that was given by the DM was that the inspectorate unit is responsible for that. Now, my question is, how will the bill address the coordination between different agencies responsible for border security, such as the South African Police Services and the Department of Home Affairs? I pause there, Chair. Thank you.
No, thanks very much, Honorable Matapa. And thanks, members, for... Is there any hand, Mr. Matonzi, before I invite responses?
No, Chair, there's no other hand.
Okay. Thanks, honorable members, for your comments, important issues that you raised. And I think all of us were aware that there are two important papers that we're currently looking at. One is the white paper on citizenship, migration, and protection of refugees, which I think is a white paper that some of the areas which were raised by members of the public, and I think in the course of the responses, will have flagged them when that process is going to kick in, including the current bill that we are dealing with of the single marriage statutes, which I think we must say it will raise some of the issues in relation to the foreign nationals, which we may tighten. So these three processes in the main goes together, but we may need to carefully craft to the extent that the legislation respond to the current issues that are confronted by the citizens of the Republic, and also in line with the Constitution. There were an issue, Director General, that was raised, and I think I'm raising it in relation to what Honorable Ngubane has raised. on the attitude of the country of origin. In the sixth administration, we briefed that there's a engagement with the neighboring countries to assist to respond to this question of cost implications, but not only that, but also to interact on the protocols that may need to be considered between two countries or between countries in terms of the legislation. You'll also recall that the Correctional Services Portfolio Committee has a detailed report in relation to the foreign nationals that are in our correctional services. So does this bill seek to respond or to enhance what may be a process that once we deal with the white paper, it will find expression. So I wanted us yourself also to go to that space at DG, DM, and the Advocate Malekat. We'll then request the Advocate Malekate to respond and invite the DG and then the Deputy Minister. Then we'll therefore invite both the Legal Service of Parliament and also the Chief State Law Advisor. And I wanted to ask caution that if there are issues that both the Chief State Law Advisor and the legal services that they may not have solicited before this portfolio committee. I'm raising this on the matter that Honorable Ross has raised, that he doesn't want to pitch you on the conflict, both the institution. We may need to step off to the extent that when the Chief State Law Advisor, Ms. Governor, present the report, the presentation, the summary of what we have done here, at least we may have find each other. But if there's a matter to be clarified along that question, you're at liberty to do that. Advocate Malekate.
Good afternoon, Chair, and members of the Portfolio Committee, Deputy Minister and Director General, and other people who are in the platform. Chair, let me start by apologizing that I had logged in with another gadget, but I could not detect that the meeting was on until the Deputy Minister alerted me that it appears that I'm having a problem in terms of connecting, and I then changed the gadgets. So my apologies for that, Chair. Chair, I think there are questions that require that deals with the practicalities on the ground that I think I would not be that the Deputy Director General for Immigration Services would need to come in and assist on that. I'm talking to issues related to the availability of the standard operating procedures as it relates to how children are dealt with by immigration officers when the immigration officers come in contact with them. From our side, it's safe to indicate that if you look at Section 150 of the Children Act, it provides clear guidelines on what any law enforcement agency within the Republic would need to do in order to protect the safety of the child. And in that respect, within our space, immigration officers need to talk to the Department of Social Development so that all the other processes that are detailed in Section 150 of the Children's Act then follows. So when it comes to issues related to whether or what happens to babies or what happens to mothers with babies, what then happens practically, I think I would leave that to the DDG for IMS. I take the cue from Honorable Ross that, and I think the Parliamentary Legal Services, as well as the Office of the Chief State Law Advisor, provided quite great examples of what could be considered as factors to to use, and how we can then understand what the interest of justice is. So at some point in time, we haven't developed the standard operating procedure on that. So as far as I know, so we think that if we were to provide that guidance in the standard operating procedure, we'll then take cue from what the Criminal Procedure Act provides, as well as other pieces of legislation on how to interpret the interest of justice. It may very well be that in considering whether or not to release such an individual, the immigration officer may even consider whether or not the person has a verifiable physical address, where in the event that they want to make contact with him, they can do so. But at the moment, I cannot clearly indicate what the standard operating procedure nor the factors would be. Safe to say that we will take the cue from existing legislation. As it relates to language, Honorable Ross, we are at pains to respond to this, because if we were to look at the Constitution and to strictly interpret the provision, it then means that the language or the interpretation services would have to be provided to each and every individual who speaks whatever language, and not be restricted to the 12 official languages of the Republic of South Africa. And even if you were to look at the jurisprudence, it seems to be going that route. And of course, it may be very impractical and also very costly. By way of an example, you can only imagine if a law enforcement agency is conducting a roadblock, and part of the roadblock is to check on the statuses of the individual. By law, and if we were to strictly interpret that provision from the Constitution, it would mean that there has to be an X number of interpreters present, and we are not too sure what language or who are we going to come into contact with at that point in time. So I think it may be very difficult if we do not indicate that where it's practical and available, that the interpretation services can then be provided. But it is not restricted to the languages that are contained in our Constitution. I think, Honorable Chair, if you would allow, the question that you have also raised, that Honorable Ngubane that speaks to, in relation to how do we ensure that the country of origins where these foreigners are coming from, who then become illegal in the country, that they take responsibility either for the deportation costs or any other costs related to the illegal entry. I think the Director General would best placed to respond to that. Say from my side to say, it may appear that they would need to be, or as we engage in the bilateral agreements or negotiations with the other countries, may very well be that it be part of the bilateral agreements. But I will leave that to either the Deputy Minister or the Director General to deal with it. Honorable Mutambi, you are quite correct. The Legal Aid Board of South Africa has certain rules that one who is seeking legal assistance from the legal aid, that they would need to pass. Similarly, they also use the means test. But and in this case, if the it would be difficult for the department to deal with the issues related to whether or not that provision to legal representation should be made. And we believe that that is outside of this bill, and that falls within the mandate of the Department of Justice and Constitutional Development. I think from the department side, what can be done and what should be done is simply to obligate immigration officers that as and when they arrest a person, they can also notify the individual that they have the right to legal representation and so on. It may very well be that possibly we can also adopt the way that the South African Police Services does, in that there is a specific form that then once you that indicate that all the rights that an arrested person is entitled to, and at the end of the day, that the arrested person can then append his signature that he acknowledges that all his rights have been explained to him, and he understood what that may be. Similarly, I think that takes care. Also, there's a question from Honorable Mohale to, I think, as it relates to the interest of justice, I have attempted to provide an answer. The reasonable conditions, it may very well be one of the, I think this is going to be part of the training as well as the operating procedures for the department. But from where I am sitting, Honorable Mukhale, it could very well be that you then indicate that between the period you would have to report before an immigration officer, by way of an example, at 7:30 in the morning. Again, you would have to report to an immigration officer at 4:00 in the morning. And I think the conditions may be circumstantial, because depending on the circumstances of the individual, if the release is then preferred. Chair, I think I've dealt with much of the questions that relate to my side, and I can leave the others to the DM and the Director General, and I think the Deputy Director General for Immigration Services. Thank you.
Okay, thanks very much, Acting UDG Matau. Is there any other matter I want to come in?
Chair, I think it's indicated it's just battling with this device where we are. Safe to say, maybe let me respond on his behalf with regards to questions by, I think Honorable Rose summed it quite well, Chairperson. What we've been required to do by the Concord is to ensure that we amend the sections in the Immigration Act that will respond to those requirements of the 2017 judgment, of the 2023 judgment. I think that's what the Concord said we must do. As I said in my presentation, Chairperson, there's a process that's underway wherein we are doing supplementary work for the white paper. And some of the comments that were made by honorable members will fall into that category. As Sarah Govenda indicated, that we have been tasked by the Concord to pay attention to certain requirements of the judgment. That's what we're exactly doing with what we were presenting. Now, there were questions that were raised by Honorable Machi on the monitoring mechanisms. I suppose this is work that Immigration and RASA and SCRA are doing by ensuring that immigration officers, where it's possible, are able to follow up on those that would have exceeded their stay or those that are undocumented at any given time. So this is work that we do to the extent that, Chairperson, you'll recall that we currently are working on a handheld device that will enable us to determine the status of anyone in the country at any given time, whether it's in an operation or a roadblock. The other one that you referred to, Honorable was, I think, Honorable, yeah, I think it was Honorable Ross on the children as well. We will share with you the SOPs, Honorable Ross. We had a workshop with all our immigration officers in 2023 to take them through the judgment, including what is our understanding. We had senior counsel of on the interest of justice and what are reasonable conditions. I think Advocate Malagat has just explained, Daksha explained their understanding as well, which is aligned to what we understand. Now, what normally happens, Honorable Ross, is that when children are found in an operation or at a port of entry, we then refer the matter to Department of Social Development, whether it's abandoned children, whether they're undocumented. They then take these kids working with us, place them in what is referred to as child and youth care centers. These are designated by DSD. While they are there, or they are placed by social workers. And they then work with the International Organization on Migration and the UNHCR if the parents are to be deported. So there's work that we do with those entities, and they greatly assist us to deal with some of those issues. So we can share with you the SOPs as you indicated. Honorable Ngubane, I think for sure DM will respond to this issue, but I think it's an issue that we're working with the BMA, we're working with the SANDF, we're working with the SAPS to make sure that we are able to utilize the resources that are at our disposal to deal with the issue that you have raised. And I suppose Parliament now has an opportunity in the next few days to influence the budget, to make sure that the BMA is appropriately capacitated, Home Affairs is appropriately capacitated. We've said it before, this committee, that we currently sit at about 39% of our capacity, which will move to about 40 because we've received approval for a further 48 positions. But I think this committee and Parliament should be able to assist us in terms of capacity. And then, of course, as you do know, Honorable Ngubane, there's work that we're doing around the redevelopment of the 6 ports. This work is about to be concluded, which will enable us to ensure that the ports of entry are properly designed to ensure that undesirable people do not come through those ports. Let me pause here for now, Chair. Thank you.
Thank you very much, DJ. DM.
No, thank you very much, Chair. And let me just thank the members for all the questions that have been asked. I think the first point first point I will just to make as an issue of comment is that we must always remember that it is Parliament that is entrusted with the responsibility of making laws in the country. And we can never, at any given point in time, usurp those powers from Parliament. So in whatever that we always bring to Parliament as recommendations, as draft bills and so on, must always remember that the ultimate power to decide on what is the best way to formulate legislation ultimately is a decision of Parliament and parliamentarians. Now, with that being said, Chair, I firstly want to deal with the issue of the rights of children and probably use a latest example when we dealt with the issue of the arrest of Chitima's mother, Rungo, who had really violated our laws. Now, we could not at any given point say, no, we are not going to arrest or we're going to be soft. We had to enforce the law. And part of the issue is that she was also, when detained, found with a baby, and we had to use the systems that are available so that the baby is not affected. So we're not talking about something that is not practical. It's something that we deal with almost every day to make sure that we partner with social development. and we will then forward the standard operating procedures on how we operate as the Honorable Ross and has requested, and also as the DG has also indicated. Now, in terms of the issue of minimizing rights of illegal foreign nationals, I think we must always bear in mind that whatever we do has to be within the ambits of the law, which means the constitution as the supreme law of the country, therefore takes effect. So we can't reduce what will be human rights or what will be rights given to everyone in the country to something that is less than the constitution does. We do hear that members are really worried that foreigners are given large room to roam about and so on and so on. And that is why we had the process of the white paper, which some of the substantive things will be dealt with in the process of the white paper when we bring it to Parliament so that parliamentarians can actually make it into law. Now, I think that will be a more extensive process, which most of the issues that have been raised really will belong into that particular platform. Now, in terms of the work of the inspectorate, the work of the inspectorate is continuing, Honorable Mbadi. It doesn't mean that because
DM, your line is not more clear. Yeah. Well, yeah, we've got some of the issues, but I think if we can shift a bit where we are. Proceed, DM.
I'm not sure, Chair, whether I'm clear now.
Yeah, more clear now. Proceed.
Oh,
yeah.
okay. No, thank you. Now, I was saying the first issue I think I indicated was around the powers of Parliament to make laws. The second issue is around the rights of children. And I was citing a practical example of the case that involved Rungo, which we had to, where we find that they were with a child and then we worked with social development. So we'll forward the standard operating procedures to members so that they are aware on what we do. And I also indicated the issue that we cannot minimize rights to the extent of not adhering to the constitution. South Africa is a constitutional democracy, so rights that are prescribed or given to everyone in terms of the constitution must at every given moment be upheld. But that does not mean that we must then treat illegal immigration with soft hands and not be hard on it. And that is why we continue with the work of the inspectorate that we are doing. In fact, if you were to look at the probably in the previous years or successive years, you will recognize that the number of inspections that are being carried out are actually increasing, and that is why we are spending so much money in deportation, because we are finding illegal people in the country and we are acting on them. But we recognize that there's still more that we need to do, like the use of technology and other intelligence gathering mechanisms that we put in place. So up until we say we don't have illegal people in the country, yes, we'll always say we want to do more. And for us to be able to do more, it requires us to have those resources. So I think the work of the inspectorate is continuing. It is happening, Honorable Ngubane. It is just that it's not at a level where we want it to be. We are now in the budget cycle. With the budget being presented, we have had obviously very high lobbies in terms of making sure that we also get additional funding to be able to get people in inspectorate, to be able to enhance our capacity, look at technology, develop the digital ID so that we have a 360-degree view of each and every person who enters the country by leveraging through technology. So those are all the things that we are doing. So we have not left that as it is. Now, let me make one fundamental point, and I think the DG also expressed on it, is that the immigration bill we are dealing with right now, or the issue that we are dealing with, is to adhere to the Concord judgment. I think the other matters that have been raised will then go to the white paper. Others will then belong to other processes of lawmaking, which is done within Parliament. But the major substantive issues will then be dealt with through the white paper. Now, interpretation, as members are saying, we cannot have interpretation being a deterrent to law enforcement at any given moment in time, where you say that here is an illegal person, you are quite sure that the person entered the country illegally, and then we say, no, we'll let you go because we cannot interpret. No, that's not how we operate. We'll find ways to make sure that we implement the law, and within reasonable way, we need to provide translation. I think that should be dealt with in the act, but it should not be. We should have a principle that interpretation should not be a deterrent towards us enforcing the law. I think I've raised the issue of the inspections that have gone up. Look, in order for us to deal with the overall immigration problem in the country, there are two things that we really need to do. Firstly, is to secure our borderline and make sure that nobody enters the country illegally. And I think the work that we are doing around the border environment and infrastructure is also going to help. For instance, development of the 6 ports of entries, which will mean that we will have more capacity in the border environment, leveraging in technology through the usage of drones and so on. And that is why we have all been saying we must fund more in terms of the border management authority so that they can have that responsibility and deliver on what is expected of them to deter people from coming into the country. The second part we have to do, because if we do not deter people from coming into the country, we'll continue wasting a lot of money on deportation, on housing illegal foreign nationals in Lindela and so on and so on, and having to comply with a number of human rights issues. But let us deter, but not leave those who have already entered the country illegal. We must continue to take action. But all in all, we were presenting on what the Concord had found to be unconstitutional in the Immigration Act, and we feel that the responses that we have provided deal with the issue of the Constitutional Court. Any other supplementary matters, we can take them elsewhere, Chair. Thank you very much.
Thank you, TM, for your responses. Can we invite Parliamentary Legal Services?
Thank you, Chairperson. Chairperson, we'll certainly act upon your suggestion to work with the Office of the State Law Advisor and to meet halfway on issues where we are wide apart. But I'd just like to venture our viewpoints in respect of some of the questions that were raised directly at us. The first was whether we agree that children are sufficiently covered in other legislation. So, Chairperson, we acknowledge that children are protected in terms of the Children's Act, that there's also the Child Justice Act, and that their rights in Section 28 are entrenched. However, our concern is that when one reads Section 34 in its current form, it can potentially impact on the rights of children because children are not expressly excluded. And the reason we say that is because the wording of Section 34 refers to the fact that an immigration officer may arrest an illegal foreigner. An illegal foreigner is then defined as a foreigner who is in the Republic in contravention of this act. And foreigner then means an individual who is not a citizen. So nowhere there does it actually expressly provide that when a foreigner is a child, the child must be afforded the protections in terms of the Children's Act. It is for that reason that we recommend that the immigration bill, similarly to how the Refugees Act has done it, expressly provide that when a child, when an undocumented migrant is found or to be a person without documents or illegal in this country, so to speak, that they then be dealt with in terms of the Children's Act. With regard to the listing of factors in respect of interest of justice and whether we consider all other legislation, yes, we can consider all other legislation. We can certainly borrow some of the factors from the Children's Child Justice Act, the Criminal Procedure Act. However, only if they would be applicable to these circumstances, for example, to determine whether it would be in the interest of justice to permit the release of an illegal foreigner. And for me, at the top of my head, if I can just think of even one factor that could be listed as a factor to be considered, could be a situation where this particular illegal foreigner has been found to previously have not complied with notices of deportation. So in situations like that, one could argue that the interest of justice would not permit his or her release. Would it be a substantial material amendment to the bill? We would need to look at what the nature of that amendment would be, but my gut tells me that should we now decide to list these factors in the bill, then yes, such amendment must then be published for re-advertisement. I'm going to just hand over to my colleague who's going to deal with the question relating to languages.
Thank you so much, Chair. This is Flora Williams. Yes, I think it's important to note that Section 35(2) of the Constitution provides these rights to everyone. And as we have stated earlier, it is not limited to citizens only. And then it specifically says that these people who have been detained need to be informed of the rights that are set out, or certain of the rights that are set out in Section 35(2) in a language that that person will understand. It doesn't specifically state that that person's mother tongue should be used, and it also does not specifically state that this should be given by an interpreter. So I agree with the department. They indicated that there might be other solutions to address this issue by perhaps drafting documents, setting out these rights in different languages, and then providing these documents perhaps in printed form to the illegal immigrants. So I think it is important to also consider other options and not only think about interpreters as a possible solution to this issue. And then I also just want to reiterate that the rights in the Bill of Rights can be limited in terms of Section 36. But if the department is of the view that it would not be able to ensure that these rights are all protected, they will need to justify that limitation. And they will have to advise the committee on the reasons why these rights cannot be given effect to. And then the committee would need to consider whether those factors actually justify the limitation to that right. I think it's also quite interesting to note that Section 6 of the Constitution deals with languages, and it does not specifically only refer to official languages. It also refers to other non-official languages, and then indicates specifically that PANSALB has a duty to promote and ensure respect for those other languages. So I think it's important to note that the Constitution does not only speak of official languages. Thank you so much, Chair.
Thank you very much. The Chief State Law Advisor, Ms. Govender.
Thank you, Chairperson. Chair, we'd like to just start with regards to the concern that was raised by Honorable Ruiz. And Chairperson, we'd like to put on record that we certified the bill, and in the process of certifying the bill, we considered all the existing legislation that exists on the statute book, and we felt that it was sufficiently offering the protection that is required. It also adequately provided for the protection of children, for Section 35 rights, and for the interest of justice criterion. And in giving the response that we gave today, that was having due consideration to those same aspects that arose in the public comments, as well as parliamentary legal advisors' presentation, as well as that of the Department of Home Affairs. And Chairperson, we still of the view that there is sufficient protection afforded in terms of the statute book and the current legislation that is in place. And based on that, the bill before the committee, in our opinion, remains that it should pass constitutional muster, and that it is in line with the Constitutional Court judgment. However, Chairperson, with that being stated, we do mention that it is within the discretion of the Honourable Committee, and we leave it in the capable hands of the Honourable Committee to consider whether it wishes to amend the bill and whether it wishes to include any other matters that the Honourable Committee may feel is relevant, or that it may be necessary to include in respect of the bill. And we will be available to assist the committee should it feel it is necessary to include any other amendments or any other, or extending what is currently in the bill. That's with regard to that question. Chairperson, I think the other question that was addressed to us was that of the language, and those provisions, from what we could see, relates mainly to the 11, or well, now 12 official languages of the Republic. And the point we were making with regard to the languages, as the wording is used in the bill, and well, as we had pointed out, was in the Act from 2002, was that those languages are not our 12 official languages. So the reason that the words appear to sort of accommodate a situation where a foreign language may not be readily available in order to give effect to that right to that foreigner immediately. And that is why that wording was put in, to accommodate where we may still have to find an interpreter or a translator in that specific language. And based on that, we feel that the wording was sufficient and did not water down the Act or the rights in this regard. Thank you, Chairperson.
Thank you very much, the Parliamentary Legal Services and the Chief State Law Advisor, the DM, DG, and Advocate Malekate for the responses. Members, it will assist us to, as we're going to deliberate, to have clear clarity on some of the issues that have been raised and responded. We'll still have to interact with the stakeholders involved on this process in our next meeting. And thanks very much for all the presentations made. They're helpful. We'll request also, Ms. Govender, that as you have been presenting, that you, as a great, circulate the presentation for purpose of reference in our next committee meeting. We'll step off the item and move to the next with the view that in our next meeting, the committee must consider, adopt a motion to proceed with the deliberation of the bill. They will draft a motion that will be carried through to the committee in the next meeting. I think they'll circulate it before that meeting so that we go through it and members of the committee consider to proceed or not to proceed. So, but so far, and I think the central is that we'll focus within the stream of the Constitutional Court judgment and what is required of Parliament to amend. Can I get Mr. Matonzi to just to affirm the process that we're going to engage on, or Mr. Adams, in relation to this subject matter?
Yes, Chairperson, is Eddie. Yeah, what we just indicated that after these presentations that we received today, and then the committee we need to draft a motion of desirability. The committee has to adopt or reject it, and then if it is adopted, and then we continue with the deliberation. If it's not approved, and then it means we have to write the report to the House. So that's what is going to happen next, Chair.
Okay, thanks. That I think will present it on Tuesday. Okay, can now step off the item. Thanks very much, colleagues, who have assisted with this process. Is there any other matter in relation to this question before proceed to another item that you think you must clarify? Stakeholders? Okay, members? Okay, thanks. Thanks very much. We'll now deal with invite the content advisor to brief on the party funding. You recall that a draft motion that the committee may need to consider. We've consulted all or received public comments. We went to the oral submissions. and they were invited Parliamentary Budget Office to give a framework. We've requested that we must begin to interact with this question. Therefore, we'll have invited Mr. Salmon to do a draft framework on how we'll be guided to deal with this draft motion. And in our next, as a proposal in our next meeting, to give members opportunity to go through. In our next meeting, we then deliberate and have to decide on how we must resolve on the matter. It's an urgent matter that must go before the House again for consideration. And we think that we're now at a better position to deal with this draft motion. It will be important that we conclude on this draft motion before we go conduct our next public hearing in merit statutes, because we'll not have time to deal with the subject matter. There are other issues that also must deal with that are related to this matter. Can I invite the content advisor to take us through? And I'll invite members to comment and legal service to comment, and if there's any comment from their part, and then we'll then subject it for deliberation on Tuesday, and then we resolve on Tuesday, and then so that we report before to the House. Mr. Salmon.
Thank you, Chairperson. Yes, I just provided a brief summary of the extensive presentation presented by the Parliamentary Budget Office, where they highlight basically that the key considerations for the decision are that we improve transparency and accountability, prevent undue influence, that there's fair political competition, and that we allow for economic adjustments. And the recommendations for the upper limit and the disclosure share threshold were comprised not of from any particular input, but an attempt to balance all the different inputs and come up with several options for which the committee can choose, which balance all the inputs from the stakeholders and from the public submissions. So the proposals for the upper limit, which is currently at 15 million rand per donor, that is quite high for a middle income country like South Africa. But the international comparison suggests that the limit should align with the GDP per capita or average income. So the scenarios or the options proposed were that you can adjust the current 15 million for inflation, bringing it to around 21 million for 2024, or link it to GDP per capita, or the average wage, and making it 100 times that, so around 17 million. Thirdly, setting a donation limit as a percentage of the donor income, so for instance 5% of the income of the person, to prevent excessive influence from one donor, or to cap a single donor's contribution at 5% of the party's total income or previous election expenditure. So those are the four suggested options. And then in terms of the disclosure threshold, the current threshold being 100,000 was viewed as potentially too low or too high, depending on the transparency goals. And the proposed scenario for this threshold are to either align it with the GDP per capita or average wage again, and to balance that with the transparency and administrative burden. So, or secondly, to maintain the 100,000 but to adjust it periodically for inflation going forward. And lastly, to full disclosure of all donations were suggested by quite a few parties to enhance transparency, as practiced in some countries. So the other considerations when making the final determination were that the introducing of spending caps, many countries limit the total election spending to ensure a fair competition. Secondly, that stronger enforcement, like regulatory bodies, including the aid within the IEC, should have more resources and legal authority to enforce donation limits. And lastly, leveraging technology to provide online disclosure platforms to enhance transparency and reduce corruption. Yes, just in terms of overview of the submissions, some were again in favor of increasing the upper limit, primarily from political parties, arguing that operational costs for political parties are quite high and increasing. Secondly, others were in favor of lowering the upper limits, such as COSATU and My Vote Counts, to prevent elites from influencing, having undue influence over political parties. And then the views on the threshold for disclosure, some allocated for the full disclosure of all donations, while others prefer raising the threshold to reduce administrative burdens. So that's a overview. And then basically, depending on what the members decide, we'll then put this in our draft resolution. We have a resolution prepared, and we just insert the relevant decision, and we can have that. We'll have that draft resolution ready on. We can send it out on Monday, and then just have the members input their decision. So that's where we stand. Thank you, Chairperson.
Thanks very much, members. This is the a framework which the content advisor has looked at. There were more other issues which I think were also raised in the deliberations, which may take into account in relation to organizations or political parties, both those that are have more strength. In other words, I'm trying to say that the capacity of running its organizational affairs throughout the country, including campaigns, that goes with the cost to that. And I can recall that part of the issues that the PBO could not even go to that extent. They could not give the a framework or a sample of a smaller party and a larger political parties and the cost therefore. And I think some of the issues that when we then proceed for sourcing more consultation around, there may be the factors that we may need to consider. The subject focus is on the threshold that must go into the draft resolution of donation and the limits. As you recall that in the Electoral Act, provisions in terms of the quantums not highlighted. So we thought that it's a matter that the committee must pay more attention so that we are able to consider this motion in our next meeting. Can I get comments from members? Or let me start with a legal service. Do you have comments on the process?
Thank you, Chair. Good afternoon to the members. We have no comments on this matter. Thank you, Chairperson.
Okay, thank you. Members, can I invite hands? Honorable Ross, Mr. Matons will assist me if there's any other hand. Okay, Honorable Ross.
Thank you, Chair. It's Friday afternoon. I'm not going to belabor the point about the need for a review of the Political Party Funding Act and its impact. But I do want to just re-emphasize the difference between an average and a mean. And I see averages here again. We are in a country that has deep inequality. We've got, I think it's the highest Gini coefficient in the world in terms of the difference between the rich and the poorest of the poor. So I just want to re-emphasize that in a country like that, using averages is not useful because there's such a big difference between the vast majority that are poor and that are very unlikely to make a large contribution to a political party. And then the top of that pyramid, which is more likely to make a contribution. So we really should consider, if you're going to consider that kind of a thing, use mean instead of an average, because with averages where you have many poorest of the poor that are extremely unlikely to make a donation, it's not a suitable measure, Chair. But that's just a technical point. And I accept the proposal in the next meeting to then consider the specifics. Thank you, Chair.
Thank you very much, Honorable Ross. Honorable Mutishimtsa.
Thank you very much, Chair. I think I will also not deliberate on the issues, but just to say that we support the approach and we will then deliberate in the next scheduled meeting. Thank you very much.
Okay, thanks very much, colleagues. Mr. Adams, you will have to, because I can, going through the documents, there are some of the factors that are not being included so that it assists members, and some of them that were necessarily not highlights of the submissions. So we'll work on that and circulate to members. We'll get all the reports just to assist, enhance the framework. And thanks, members, for accepting that approach. So we'll again request that we go and obviously we've been taking this decision that we must engage and consult. And I think we've able sufficiently to do that on Tuesday. We'll then deliberate and take a decision on a draft resolution that must go before the House. I'm fully aware, Ms. van der Merwe, that also there's a court process or a reserved judgment in relation to the subject matter that Parliament is engaging on. Is there any other matter, Mr. Matonzi?
Chairperson, no, there's no other matter.
Okay.
Except that already I've sent out the notice for the GPW presentation next week and BMA. So I should include the deliberation on the immigration and political party funding as well.
Okay. Honorable Mukhale?
No, just clarity, Chairperson. The draft resolution, when are we going to receive it?
I know that when it was tabled, we tabled a draft resolution. If Mr. Matonzi, we can recirculate the draft resolution before the committee, which was also it was presented by Parliamentary Legal Services, if I'm correct, but also subjected to this committee deliberation. If you can just recirculate that draft resolution, Mr. Matonzi.
Yes, I'll do that.
Okay. Thanks very much, members. In the absence of any, the meeting stands adjourned.
Thank you very much, Chair. Goodbye.
Thanks, Chair. Bye-bye.
Thanks,
Chair.